All rise. The Arizona Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated. Do we have a sign-in sheet? Thank you very much. This is a time set for oral argument in State versus David Levy Greenberg, our case number CR130445. Each side is allocated 20 minutes for argument. Appellant may reserve a portion of that time if you wish to do so. Sir, you'll need to keep track of that time using the podium clock. We have granted a request for Appellee's counsel to present argument seated at the table, so the court is aware of that as well. Now, out of respect for counsel, I would ask those in attendance to make sure that your phones are either on vibrate or turned off so that they don't go off during the course of argument. We have reviewed the briefs. We've conferenced the case this morning. We encourage you to keep that in mind as you present your oral argument. We also, at least one of the briefs cites some transcripts that were not part of the appellate record. We have, through our clerk's office, asked the clerk of the trial court to provide those to us. If counsel has those and wishes to lodge those with the court, that may speed things up a little bit as well, but I defer to you on that. But we do not have them as a part of our record. Our proceedings are being recorded and will be posted to YouTube. As you begin your argument, please state your name and the party that you represent. With that, Mr. Bednar, you may proceed.
May it please the court, good morning. My name is David Bednar, and appearing on behalf of David Levy Greenberg, who is not here today. He is currently housed at the Department of Corrections here in the state of Arizona. And first of all, I'd like to apologize for a typo in my opening brief. And under questions presented for review, there were two different questions that I cited. However, that was a typo. There should only be one, and that's number one as is presented. Number two was included by mistake. I had that in my original draft, but I deleted that for my final version.
And counsel, just to be clear, that refers to what has been referred to sometimes as the second confession. You're withdrawing any argument challenging that interaction with law enforcement.
That is correct, Judge.
Thank you.
What I am challenging, or the challenge that we do bring to the Court of Appeals, is whether the trial court abused its discretion in finding the trespass confession was admissible at trial. And it seems that from the explanation that was given by the trial court based their justification in overruling the previous ruling, which ruled that the confession was coerced, that the new judge based her decision on good cause. And good cause would have to have some type of basis, something different, judges, from what was originally presented in the two-day evidentiary hearing back in 2009. And when the state filed their brief and their state, and it was titled "The State's Motion to Admit Defendant's Statements as Voluntary," and they did so in December of 2012. Our original evidentiary hearing was back in April 13th of 2010. And between 2010 and 2013, there were no new facts, there was no new evidence, there was no change in law, and there were no change in the rules. What the trial court did was they sat as the Court of Appeals. What she did was she reviewed the evidence, and then she stated, even an appellate burden, she stated that it was clearly erroneous that the trial court made the decision that it did based on listening to all the same facts, reviewing the transcript of the evidentiary hearing.
What exactly did, and I think you're talking about Judge Nichols now, right?
That's correct, Your
What
Honor.
exactly did Judge Nichols have? Did she have, she had a DVD of both interrogations, if I understand the record correctly.
That is correct.
And a transcript, I assume.
Yes. She had a DVD, the same thing that Judge Hendricks had in the initial evidentiary hearing.
Did Judge Nichols have a DVD or possibly an audio recording of the 4 officers' testimony at the original suppression hearing?
She did not have a audio recording, Your Honor. What she had was a transcript. It was a very thick transcript because it was a 2-day proceeding. And what she did, she reviewed that transcript. There was no videotape, there's no audio tape of the initial 2-day hearing.
Counsel, let me ask you mentioned good cause. Where does that, from your perspective, your client's perspective, where does that standard originate? What is the basis for that standard?
The way I would interpret it, Your Honor, is that for good cause would indicate some type of change in law.
And I understand that, but just even the phrase good cause, where is that a rule standard? Is that a statutory standard? Is that a...
I'm sorry, I misunderstood the question. Yes, I believe it's seated in Rule 16D that would give a trial court the opportunity to review a previous hearing for good cause.
And
what
does Wayland do, though, with that argument? Doesn't Wayland say that 16 applies to a given case, not from one case to the next?
I think that the way Wayland applies 16 is that if you have good cause, then you'd be able to review. But without good cause, you'd have to rely on something else. And in Wayland, what they relied on was the change in law. And that was the good cause.
Well, they ultimately did that when they did not address res judicata, as I recall.
That's correct.
But with respect to or collateral estoppel, to use the term that they do, and I'm looking from a copy of the draft, but when they talk about law of the case in 16.1D, it seemed to me that the court on those two grounds said, look, those apply in the same case, not from one case to the next. And if that's a fair reading of Wayland, what does that do to you? How does that affect your argument?
Well, I think we do have the same case, Your Honor. I think we have the same case as we did in 2009 as we did in 2013.
Similar.
It had a different trespass charge, didn't it?
It did add a different trespass charge.
I guess it had a couple of trespass charges, the new case.
That's correct.
Neither of which were the one that he confessed to in the confession.
That
is correct.
And the go ahead.
I'm probably jumping in on yours, Judge Thoma, but doesn't that at least technically make it a different case?
It makes it a different case as far as there are 2 new charges, but as far as, well, I suppose when the court would look at a different case, I would think that it meant that there are different facts, there are new facts, there's something different that could be added to the argument that the confession was not coerced. There was nothing added. Yes, the new charges were added, Your Honor, but there were no new facts added to any of the evidentiary issues that would give the court any good cause to overturn the previous ruling.
So if the state dismissed a case with and then we indicted the defendant, then that's the same case?
Pretty much the same case, because all of the charges, other than the 2 new trespass charges, were added to that indictment. When you looked at the indictment from 2009 and you look at the new indictment, which I believe was 2012 after a different division overruled my warrant issue. Once that was refiled, all of the pornography charges, all of the all of the sexual exploitation charges were the same. In fact, we realized that 2 of the files were the same, and one of those charges was actually dropped.
Under that expansive definition of case, how do we determine when we have the same case or a different case if we have to look at the facts to make that determination?
I'm sorry, I didn't understand the question.
It seems to me that a case is based on what the state is charging rather than what the particular facts are. If we determine when a case is based on what the facts are, that's going to be a lot more difficult than just looking to see whether an indictment or an information has been dismissed or maintained.
Well, Your Honor, I think for the purposes of a different case, when we're looking at the facts of this specific case, if we say what is different in this case, what makes it a different case other than the cause number, other than it was dismissed and it was re-indicted and all of the same charges and 2 new charges were added, then I think it's fairly easy to say it's the same case. Additionally, when we look at appellate review, what we had in the original case was several motions that I filed. I filed a motion that challenged the arrest, the detention, the Miranda. I filed a Fifth Amendment motion. I also filed a Sixth Amendment motion with regard to the coerced confession, and then we also had a Franks hearing on the warrant. There were several issues that were covered in that 2-day hearing. And once the judge made her ruling on that 2-day evidentiary hearing, there were 2 decisions that came unfavorable to the state. One was the warrant, one was the coerced confession. At that time, the state chose only to challenge the ruling on the warrant. It chose to ignore the fact that it received an unfavorable ruling on the coerced confession.
Is it possible that had something to do with what turned out to be an eventual plea on the trespass charge?
I'm sorry.
My understanding is that your client pled guilty to I guess misdemeanor trespass while the search warrant issue was up at this court.
Yes, Your Honor. He was being held in custody. Once I received the favorable ruling and the warrant was overturned, a strategic decision at that point to get him out of custody was to plead him guilty to the misdemeanor trespass. Then he was placed on probation, went back to Delaware, and was serving out his term of probation when a different division overturned the warrant issue, and he was re-indicted.
Well, counsel, if your client pleaded guilty, then why wouldn't the state contest the suppression of the confession at that point? Because your client is pled guilty, the state doesn't care at that point.
Well, the issue was still before the state. They had no idea what the court may have ruled in the future. And I believe
it just seems odd that if the defendant pled guilty, then there's really no controversy for the state to pursue on the confession at the point. Am I misunderstanding?
Perhaps. I would respectfully disagree with you, Your Honor, in the fact that the confession was used as a basis for the warrant. Him pleading guilty to the misdemeanor trespass charge didn't unilaterally, or it didn't somehow magically allow the state to use that in an affidavit to obtain a search warrant to get into the house. That's what I think is one of the key factors that the state should have relied on, or at least should have thought about when they were appealing the warrant issue, that you have a coerced confession that was used as a basis to get the warrant.
But they still they appealed from the suppression of that warrant, correct?
That is correct.
And they didn't challenge, so I mean, from the state's perspective, by challenging only the warrant, not the confession, they didn't think the warrant was based on the confession, right? I mean, because the confession was excluded by the trial court, as was the warrant, and they appealed to this court, and this court reversed the warrant only.
The confession was incorporated, if you will, Your Honor, into the warrant. The first paragraph of the affiant statement states that we interviewed him. During this interview, these are the facts he gave us, and that was used.
And I understand that, but the state still appealed from the suppression of that warrant and won without the benefit of the confession, correct?
That is correct.
And let me ask just a timeline. There's the order finding the warrant and the confession are not admissible, or excluding the fruits from the warrant. And then there's an appeal at some point in time, soon after that, by definition. Your client pled to the misdemeanor trespass at some point. Was it prior to do you recall whether it's prior to the notice of appeal or after the notice of appeal?
I don't recall. I would have to check with the index, Your Honor.
And it's been a while. And
It has.
That's fair. That's fair. Please proceed.
I suppose that the basis of our argument is that it seems that we have a specific set of rules for the trial court. We have a specific set of rules for the Court of Appeals. And what we have here is, I believe, collateral estoppel should have applied, because what it does is it disregards all of the rules and the structure that we have in place for appellate review. When the opportunity arose for the state to appeal this decision, they chose not to. And that's why I argued in my brief that they had waived at that time, and I argued that to the trial judge as well.
So you're in essence arguing not only that the state obviously had the opportunity to appeal the trespass confession ruling, but that they must.
Yes. Well, they should have, yes.
They must, or they're stuck with it. That's your argument.
That is. It becomes law of the case. And
does it matter in your position whether the state is appealing another ruling, such as the search warrant ruling here?
does it matter?
Yeah.
Yes, I think it matters quite a bit. And the reason that it matters is because you have all of these issues. You have this opportunity to clear things up, to come back if you win and re-indict the defendant. You're going to come back knowing what the rules are, what type of opinions you have with regard to the admissibility of evidence at your second trial.
When this one went back after our ruling, what was the state of things? Would you agree that it was known at that point that the search warrant evidence was okay, but the trespass confession was still under the ruling of Judge Hendricks at that point?
Yes, I thought, because there were, as you've worked with different county attorneys, different prosecutors, you have a prosecutor that's assigned to the case. You've been working with him for several years. He leaves, a new prosecutor is assigned, and I was somewhat caught off guard that now this was being challenged. I thought that we were living with the ruling from Judge Hendricks and the original ruling, and that's why I argued that collateral estoppel should apply, because they had the opportunity and they chose not to.
And your argument is that the dismissal without prejudice was a judgment in the prior litigation. Is that correct?
Yes, Judge. When we look at collateral estoppel, there's a few different things that we look at. You have to have the issue was actually litigated in a previous proceeding. The parties had a full and fair opportunity, which they did here. It lasted 2 days. They also had the same incentive, or there was equal incentive by the defendant and the state to reach a ruling on the admissibility of this evidence. And also, when we look, or there was mutuality of the parties. But another thing that you look at is the finality. I know there's a lot of argument, well, this case was dismissed. We don't have finality because there was never a jury verdict. But the jury's not going to decide the admissibility of evidence. It's the judge that makes that legal ruling. There was no tentative type of ruling that was made in this case by Judge Hendricks. There were no developing facts, nothing new, no change in law. It was a final decision for the purposes of this case, Your Honor. I only have 2.5 minutes, and I'd like to reserve that for rebuttal.
Very well.
Thank you.
Thank you, Counsel.
And I was just going to leave my paperwork here since he's
I assume there's no objection to that process.
No objection.
Very well. Thank you, Counsel. Mr. Solon.
May it please the Court, Craig Solon on behalf of the state. Starting with the law of a case analysis, we have two different cases. Under Whalen, when the state dismisses an indictment without prejudice, and then refiles the indictment, there's a brand-new case, and law of the case no longer applies.
Counsel, does it matter if the facts are otherwise identical?
The facts were otherwise identical in Wayland. But
More identical, perhaps.
yes, more identical. But it really doesn't matter that the facts were otherwise identical. Here, actually, the trespass claim that appellant is complaining about went out of the picture prior to the new indictment. But just from a basic law of the case standpoint, you don't have the same case anymore, and that's what Wayland said, and that was absolutely correct. But even if you did have the same case, the trial judge still has the ability, even in the same case, to reconsider not only the trial judge's prior rulings, but the rulings of another court, of another judge prior to trial.
But under the rule, then the judge would, Rule 16.1D, I think it is, then
Right.
then the judge would need good cause.
Right, and that's exactly right. The court has the discretion to entertain and to make new rulings as long as the court has good cause. And then under cases like Martinez, certainly an incorrect ruling or a ruling that causes manifest injustice would certainly constitute good cause, even in the same case, and we're not in the same case.
Yeah.
But here, if you are taking a ruling that a trespass confession was invalid and attempting to use that ruling to derail a child pornography confession that occurred 4 days later, and that it was based on completely different facts, and where there's no connection between the two, it's obviously a manifest injustice situation, and that comes into play in the collateral estoppel analysis too, but just for law of the case analysis. So no same case, an incorrect ruling, and manifest injustice, and you can't. It doesn't apply no matter how you look at it for law of the case.
Let me ask you a question about that, and then move back to the world where these are considered as two separate cases. I want
Right.
to follow up there, but if that's the case, if it was unrelated, how was the trespass confession relevant?
The
in
trespass
second case?
confession wasn't relevant.
But
what-
we're here because it was a. It was,
We're here because, and the state spelled out why it was doing what it was doing. Once Judge Hendricks ruled, the state's concern was that the search warrant was suppressed. It had other evidence on the trespass. I'm reading between the lines on this aspect of it, but it had other evidence on the trespass. It had all of the independent evidence, and so it goes up, and Judge Hendricks didn't even rule on the child pornography confession, because without the search warrant, that aspect of the case wasn't going anywhere. So once this court overturned Judge Hendricks' suppression ruling with respect to the search warrant, and the state refiled the action, and again without the original trespass, which in the meantime had pled out, the state approached the court with the concern that the defense was going to say that something about the trespass confession somehow affected the child pornography confession. Now, the appellant never challenged the search warrant again after after it came back down, and under law, the case analysis could have, but didn't.
Well, let me ask you about that. So in other words, your position is the mandate in case 1, okay, for purposes of considering this appeal as case 2.
Right.
When was irrelevant to how the parties proceeded under the new indictment?
Under law, case analysis, yes. And obviously, if this court had published a decision, it would apply
As
by virtue of
precedent.
stare decisis. But otherwise, you have a new case. Appellant did not challenge the search warrant.
Doesn't that suggest then that the prior appeal effectively was moot and should have been taken?
Well, the prior appeal had both had effect in the sense that it resolved those issues that could have been challenged again by the appellant. Appellant didn't challenge.
But in a
them
persuasive way, not in a
again.
binding
In a persuasive way.
So
That's
if the
right.
state had taken the appeal on both issues, the trespass confession and the warrant issue,
Right.
and had lost on both, your position is the state could start anew in the new indictment?
It could have, but the result would have been a foregone conclusion, one would think, when the trial court looks at a ruling of this court, whether it's by memorandum decision or otherwise. But it's not the same case.
But it's persuasive only, and the court could say, yeah, you know, three
Well,
people somewhere else looked at it, and you
Unless
know.
collateral estoppel applies, or unless law of the case applies. And here, law of the case doesn't apply because it's not the same case. Collateral estoppel doesn't apply because there has been no determination or no issue of ultimate fact decided and no valid and final judgment. And without those cornerstones, you don't have collateral estoppel, and you don't even need to get to whether the Whalen exception applies. But the Whalen exception does apply because you have a totally different legal context.
Well, and Whalen, of course, didn't go off on collateral estoppel. It kind of reserved the issue for
No.
another day.
It didn't go off on law of the case. It looked at collateral estoppel.
Rejected law of the case.
It didn't. It said the law of the case doesn't apply because you have two different cases. On collateral estoppel, it said we're not going to get to the issue
Right.
of whether under regular collateral estoppel principles it applies because there is this exception.
Let me ask you, isn't the not in this case, or not in these cases, however you want to phrase it, but isn't the logical extension of the state's argument in this case that if you charge a suspect, charge a defendant, have some pretrial evidentiary hearings, get some rulings the state doesn't like, the state then dismisses without prejudice, files a new indictment the next day, gets a new judge, and everything's new again? Can't you? What's the if that's the case? What's the check on that?
There are checks. There is the check of the trial court and whether the motion to dismiss is going to be granted with or without prejudice.
On the first case, though, the odds of it getting with prejudice are tiny.
Right, and there is, but at some point there is the check that there is the check that the court is going to look at the ruling of the prior court, whether it's bound by that ruling or not. And there is the check, if too much time passes, that you are going to have a situation under the Sixth Amendment.
A constitutional speedy trial issue, not a rule
Not a Rule
bound
8,
speedy.
a constitutional.
Which typically is years, not months or days.
Right, but all I'm saying is there are checks, and there is the check, obviously, of double jeopardy if jeopardy has attached, and here jeopardy didn't attach.
Because the jury wasn't sworn.
Right.
And typically that would not be the case if the state got a pretrial. I mean, we haven't gotten to the point, and I hope not to get to the point, where the state would seek to dismiss in the middle of trial. We're talking about
Well,
pretrial.
then you have a totally different kind of issue. But
Counsel, then, and to follow up on Judge Furman's question, what prevents the state from drug shopping in effect if the state doesn't like the court's ruling, we'll just dismiss and start over again.
There isn't a specific rule in place that prevents the state from refiling an indictment, is what I'm saying, from refiling an indictment in good faith. And we're not talking in terms of ethics here, but refiling an indictment in good faith, and then relitigating that case. In that situation, you don't have law of the case, and you don't have collateral estoppel if it was an interlocutory judgment. Obviously, if it is an issue of ultimate fact and a valid and final judgment, you have collateral estoppel kicks in.
But with to use your definition of good faith, which is different than any ER
I was
chapter
using that
and
in the
verse,
courts
right?
in a judicial sense.
But is dismissing without prejudice and refiling to avoid the force of a pretrial ruling a good faith filing?
But obviously, that isn't what happened here.
I understand that, and I'm talking hypothetically. I completely understand that.
Judge shopping is not what I was talking about when I said good faith. I wasn't talking about judge shopping, but that didn't happen here because you had a very logical scenario. When this went up, it went up because the dog, the tail being the tail being the trespass, the class 6 felony for trespass, the dog being 20 counts of child pornography, 2 counts of surreptitious videotaping, and 2 counts of voyeurism, and 2 other counts of trespass. That's the dog that was derailed by the improper suppression of the search warrant. So once that gets put back in play, and appellant has been, keep in mind, appellant has been out of prison this whole time, back in his home. He's not prejudiced in that sense. Now, no one wants an indictment hanging over their head, but the state in a situation like this may never refile. It depends on whether the state thinks it can and whether it thinks it's appropriate to do so. But here it was clearly appropriate once this court turned around the suppression ruling.
But in your argument, that suppression ruling was sort of irrelevant in the second case.
Well, the suppression ruling was the suppression. Which suppression ruling?
That this court reversed and found, that the warrant was proper. Your argument is, that appeal was interesting but wasn't binding on anyone.
Appellant could have. Well, it's an important thing that appellant could have but did not challenge. Under Whalen, appellant could have but did not challenge that search warrant.
That seems surprising to me. I think I understand Whalen's distinction between one case versus 2 cases, but it seems surprising to me that our memo decision in 2011 wouldn't have been rather strongly a law of the case.
Well, if it's a separate case, law of the case doesn't apply.
Well, Counsel Ling, I don't understand then why the state would bother pursuing appellate review for the search warrant, because if our ruling isn't binding, at least in that issue, then what are we doing reviewing that, and why doesn't the state just ignore the court's ruling and refile?
I don't know that the state even thought about that, Your Honor, but I do know that once this court made up its mind and reversed that ruling, it changed the whole landscape of the case. That was the important thing. Now, what I'm saying is that law of the case doesn't apply, collateral estoppel doesn't apply, but for all practical purposes, the landscape of the case applied.
So the court the court merely issued an advisory opinion?
I think when this court issues a memorandum decision, even when it's not law of the case and it involves the same facts the trial court sits up and takes notice.
Well, I'm sorry, counsel. So you're saying that is this persuasive authority for the trial judge?
Well, one would think it would be very persuasive, but it is not law of the case. It is not binding in a law of the case situation.
So any time, if I'm following this correctly, given this, what to me, with a civil background until I came here a few years ago, it has always seemed odd to me that the state could appeal from a case that's been dismissed. You know, I don't believe we can do that in the civil practice. If the case is dismissed, it's over. You can't appeal. But here it's dismissed without prejudice. Then the state appeals, and I understand this procedure has been blessed by our Supreme Court some years ago. But you're saying because when it goes back, there has to be a new case filed, then any time we rule, whether it's a memo decision or an opinion, it's
Law of the case doesn't. Law of the
it's
case
kind of an
doesn't apply.
exercise in futility.
And even if this court disagrees with me,
I'm just
and
surprised.
that's law
I never thought this part through that you're leading us on.
I didn't until I analyzed the case in light of Whalen. But even if this court disagrees, law of the case still doesn't apply because the trial court didn't abuse its discretion. It had good cause to revisit Judge Hendrick's erroneous ruling. It had good cause both under Rule 16 because the ruling was erroneous and because there was injustice, and collateral estoppel doesn't apply, again, because there was no issue of ultimate fact determined. Can I
need to ask you about the exception that you've referenced and
Sure.
you argued in your brief.
Sure.
I understand the exception in the Whalen case, the Okovage decision.
Right.
Probably don't pronounce that correctly, but I understand that. That's real. To me, that's real simple.
A lot changed.
I don't see that here. But you're saying the landscape kind of generally changed because one trespass count is out, two new ones are in, and we have issued an advisory opinion on the warrant ruling.
Well, I wasn't. I wasn't.
I know you didn't say that.
No, I wasn't on the trespass. I knew you were joking on the. Well, I knew you were.
I'm mildly troubled by it, but I'll
Yes.
think about it some more after we're done.
But I wasn't. My argument wasn't based on the new trespass counts.
Help me out.
I do agree that yes, the exception is distinguishable in the sense that
from Whalen, that's different.
In the Whalen case, there was a change in law. Here there wasn't a change in law, but the distinction or the exception still applies, and it applies because the cases you look at, it says the legal context has changed.
I'm not sure what that means.
And well, here the legal context changed mightily because, again, you're not talking anymore about whether a confession is going to be admissible in the terms of prosecuting a Class 6 felony. You are talking about part of a two-step analysis.
You mean the legal context changed because of this court's ruling?
Well, in a sense, it did also because the legal context said we can that the search warrant evidence was still alive.
Yes.
And that this court opined that Judge.
I mean, that's a huge point.
It is a huge point, and that's what prompted the state to go back and to say, look, we want to resolve this whole issue. We have two arguments. First is that Judge Hendricks got it wrong, and it was voluntary. Second, even if it was, under attenuation analysis, nothing about that trespass confession affected the child pornography confession because by the time that happened, you had an execution of a perfectly valid search warrant, which hadn't been re-challenged in the second action. And not only did you have all that change in circumstances from the search warrant, But obviously, by that time, he already knew that the trespass on the first incident was a felony and not a misdemeanor. So under Wong-Sun attenuation analysis, the trespass confession had no conceivable bearing on the child pornography confession. The courts never held that there's just a but-for per se exclusion. It was small, allegedly involuntariness issue in the first one, and then everything downstream somehow automatically comes out. Before I can't see the...
I see your time's up, but I'm hoping that our presiding judge will allow me to ask another question or
Very
so.
well, you may.
Sure.
And counsel will give you 30 seconds, and we'll add
Thanks.
some more time on both sides to sum up.
Let's say I agree with you based on Whalen, or agree with the state based on Whalen that this is two cases, and so law of the case and 16.1b are out. And let's say though that I would agree with you that collateral estoppel doesn't apply if there had been one or two adverse rulings, here two by Judge Hendricks, and the state didn't appeal. Just dismissed for a while, went back and refiled and attempted to move the case. I would agree collateral estoppel didn't apply. Those were interlocutory rulings. Let's assume that's my position. But it does strike me as different when the state chooses to appeal one of the two rulings and doesn't appeal a second one. Can you comment on that, please?
I have never seen in the context of state appeals a situation where the state has to appeal it or lose it with an interlocutory suppression ruling. Requiring the state to do that would be a problem at several levels. First, you don't know how everything is going to play out, but in this case in particular, it's a good example because there was no reason for the state to appeal the trespass confession ruling because it concerned the trespass confession, a Class 6 felony. It wasn't until this court held that the search warrant suppression ruling was invalid that the state had every reason to bring that back up again in a different context. If you force the state to just think of every little permutation in when there is a interlocutory suppression ruling like that, this court would be dealing with problems that may never arise. And I guess that's my best answer to your question, is that no case that I found talks in terms of waiver, and certainly collateral estoppel doesn't apply, and law of the case doesn't apply for both reasons that I've.
Thank you.
Counsel, you need a list.
And I wanted to make one comment just in terms of appellant's statement in his reply brief that Judge Hendricks found that Detective Holyfield's testimony that he didn't know that this was a felony until the last break was somehow not credible and somehow did not accept that testimony. That's just wrong. It's not part of the record in this case. If the court wants to see it, we're happy to provide it. But Judge Hendricks in no way rejected Detective Holyfield's testimony on that score, and as a matter of fact, affirmed it.
What part of the record would you submit to us? A transcript?
Well, there's a ruling that is, I don't know, 15, 20 pages long, but on page 14 of that ruling, it wasn't made part of the agreed upon record, but page 14 of that ruling, she starts off saying, in fact, Detective Holyfield honestly testified. and then it goes on. I can read the whole thing to you if you like.
It's odd to me that that's not part of our record here.
I'm happy, I have it with me, I'm happy to provide it, I'm happy to file it after this if the court would like it. But-
What is that?
Pardon?
What are you reading from?
I'm reading from my notes, obviously, but I copied them from Judge Hendricks' ruling, which was the ruling that was part of the record in case one.
Okay.
That was appealed and turned around. All I'm saying is I wanted to correct the factual issue, and Judge Hendricks did not, in fact, say that or reject Detective Holyfield's credibility in that regard.
Thank you, counsel. Let me ask our bailiff to put 5 minutes for rebuttal. Total, yes. And Mr. Bednar, while that's happening before your time starts, do you have any objection to the state supplementing the record to include that complete minute entry?
Not at all, Your Honor.
Very well. So, Mr. Solon, if you could get that on file in due course, I'd appreciate it. Thank you.
And the court does have the evidentiary hearing from Tuesday, April 13th. That transcript is part of the record.
We have no transcripts.
I thought this was
Well, we have
We have-
some transcripts, but we
That's-
don't have the January 23, 2013 transcript of the argument before Judge Nichols.
And that's fair. I'm sorry. We do have some transcripts. I apologize, counsel, for that mistake.
But that's the one you need?
That's the one we have
The one,
requested.
yeah, that's the one Judge Thummel was referencing primarily in the opening.
And from our clerk's office is contact the Superior Court clerk's office. And we will, just so you're clear, so you know exactly the record we're working off of, when we get, presuming we get those from the clerk's office as opposed to from counsel, we will provide a notice indicating what transcripts we've received so you know what we have, okay?
Thank you.
All right.
We were pretty sure you both had it, but we
Yeah.
didn't. We weren't able to find it.
I brought all the transcripts just in case there is some type of dispute. But thank you, Your Honors. The reason I cited to the transcript with regard to what Judge Hendricks might have thought was because Judge Hendricks was able to sit through 2 days of evidentiary hearings. She was able to judge the credibility herself. An opportunity that was never provided to Judge Kathleen Brown Nichols. And during that time, one of the officers stated, he was specific, and he stated under testimony that you have to get him to admit he was standing on the ledge so we can charge him as the felony. For Detective Holyfield to then say, oh, this was a mistake the whole time, is not credible. We have an officer telling him, here, we've looked at the statute book, this is what we need you to get him to say. And that's exactly what Detective Holyfield went in and done. That's why I referred to that as perhaps being a point of doubt that Judge Hendricks may have had with Detective Holyfield's testimony. But back to what I think was being addressed at the very end of the argument was the Attorney General's office stated that there would be a big problem if we or if the state was required. And Judge Gemmell, you brought that up. You said, must they? And I believe that the bigger problem is not to require the state to appeal all of these issues at once. And the main policy reason for that is what we're going to have are judges from equal jurisdiction sitting on the same bench, overruling one another on the same exact facts. There's no reason to have that even as a possibility. That's why we have the Court of Appeals. And what it sounds to me like is the state is advocating for the proposition that a trial court is justified in assuming the mantle of the Court of Appeals, which it is not. That's why all of these facts that were elicited during the testimony, they were judged by the Honorable Dana Hendricks, who had the opportunity to review and to see the credibility of the testifying witnesses. That's why Wayland doesn't apply. There's no good cause. All it is simply Judge Kathleen Brown Nichols assuming the mantle of the Court of Appeals, looking at the same exact facts and saying, as the Court of Appeal would, this was clearly erroneous. And that's the job of the Court of Appeals. And the prejudice lies in the fact, although he had not made a motion yet, but Mr. Greenberg could have used the ruling from the trial court that the confession was coerced in order to challenge or make a subsequent challenge of the warrant, saying that if we had another Franks hearing and we excluded the statements that were elicited during the coerced confession, if we exclude those from the affidavit for the warrant, perhaps the warrant would not have been granted.
But let me ask, do I understand your argument on that point to mean that the warrant was still at play even with the prior appeal? In other words, you just indicated, if I heard you right, that in the second case, if Judge Nichols had found that the trespass confession was not admissible, that you would be able to challenge the warrant that had, even though the Court of Appeals had already addressed that issue. Is that correct?
No, the Court of Appeals never addressed the issue. The Court of Appeals addressed the issue with regard to the warrant separately from the confession, those statements being used.
Right, but your point is you believe it was still in play to challenge the warrant based on the trespass confession, independent of what the Court of Appeals in the first appeal said?
Yes, Judge Thurman, I think that it was still in play for the aspect of challenging the warrant on that specific issue, taking those statements out. So that was never, excuse me, Judge, that was never argued before Judge Hendricks. It was never argued before Judge Kathleen Brown Nichols.
So if I hear you both in that respect, the prior appeal from very different perspectives was not a final determination of really anything. Is that?
I disagree. The way I interpreted the Court of Appeals opinion overturning the warrant was that the warrant stood based on specific issues. Number one, that they did have, because I challenged that it was overbroad, that it was in particular. And what the court says was, no, what would be allowed here is that law enforcement would be able to go into that house and search for any motive of the trespass.
Okay, and in any event, even if you're right that the warrant was challengeable in the second case based on the confession, that challenge did not occur.
It had not occurred yet.
Okay. Well,
based on the fact that the court said it's coming in. You don't get to argue that, Mr. Bednar.
But so you agree, I take it, that you're bound, the parties are bound by what this court said on the issues raised in the earlier appeal.
Yes, Judge Howe, I do agree with that statement that I was bound from arguing any further with those specific issues addressed by the Court of Appeals on the warrant. I do agree. Thank you, Your Honors.
Counsel, we really appreciate your presentation and your briefs. As you may not know, we don't always have oral argument in criminal cases, and this has been very instructive, and I appreciate your efforts, both today and in advance. We will take the matter under advisement. We'll issue a ruling in due course. Thank you.
Hey, nice to meet you guys. Take care. Thanks a lot, Ethan.
Thank
Nice
you.
to meet you.
Nice to meet you.